National, the International Criminal Court is now in session.
Thank you. I would like to open today's hearing. And first, I would like to introduce the members of this bench, the judges. I will introduce myself, and then I would like to ask my colleagues to also introduce themselves briefly. My name is Philipp Osten. I'm a professor of criminal law at Tokyo, Japan. Good afternoon from Tokyo. Thank you. May I ask Ms. Judge O'Leary, please, to introduce herself?
Sure, thank you. Good morning, good afternoon, good evening, wherever you may be. And my name is Marie O'Leary, and looking forward to today's hearing.
And greetings to everyone from me. And my name is Matthew Cross, and I'm also looking forward to today's hearing. Thank you very much.
Okay, thank you very much. Next, I would like to ask the parties to briefly introduce themselves, and I also would like to ask you to indicate how you plan to allocate your pleading time.
Good afternoon, Mr. President. My name is Ekaterina Fakirova, and I'll be the first speaker for the prosecution, and I will speak for 15 minutes. And Mr. Fikri Faruqi, my co-counsel, will be the second speaker for the prosecution, and he will speak for 10 minutes.
Understood. Thank you very much. Defense, please.
Your Honours, my name is William Liu, and together with my co-counsel, Erin Cagney, we represent the defence. I will speak for 12 minutes on jurisdiction, my co-counsel for 13 on admissibility and responsibility.
Thank you. Okay, I would now like to give the floor to the first speaker of the prosecution.
Good afternoon, Mr. President. Good morning, Your Honors. May it please the court. For 6 years, a single individual transformed the state of Hanatun into a coordinated machine driven by discrimination. And predictably, this environment of hatred culminated in acts of genocide perpetrated by the gears of the Hanatun apparatus, to which Mr. Gravis simply turned a blind eye. The prosecution today will make 3 submissions. First, that this case is admissible. Second, that the court has jurisdiction. And third, that Mr. Gravis is criminally responsible for both counts of genocide under Article 28A of the Rome Statute. I shall address the first 2 submissions, and my co-counsel will address the last. Turning to our first argument, we submit that the case is admissible, and we will focus on the contentious issues of complementarity. Your Honors, pursuant to Article 17(1)A of the Rome Statute, a case will be deemed inadmissible when it is either investigated or prosecuted at the domestic level. However, it is not sufficient merely to assert that investigations are ongoing. And from the Kenya Appeal Judgment, paragraph 2, we know that tangible proof to demonstrate that a state is actually carrying out relevant investigations is needed. And furthermore, there must be evidence with probative value, and most importantly, a sufficient degree of specificity. And this evidence may take the form of interviewing witnesses or suspects, documentary evidence, forensic analysis, and it may also include directions, orders, and decisions issued by the authorities in charge of the investigation, as well as internal reports, updates, notifications, or submissions contained in the National Investigative File Analysis. And this was elaborated in the Gaddafi admissibility decision. Your Honors, this is the level of specificity required. And in our case, we have nothing but mere assertions that investigations are currently ongoing in the Republic of Hanatun. In case fact 18, we only have a mention of the establishment of the military court and that it will finish its investigations later on this year. We have absolutely no information on, for example, the beginning of the investigations, on the concrete and progressive investigative steps that the Republic of Hanatun is taking, or even information on who the prime suspects are. Let alone we have any information from the Gaddafi admissibility decision. We have none of that. Therefore, Your Honors, there is no concrete, tangible, and pertinent evidence which is required that proper investigations are currently ongoing in Hanatun. Therefore, this case should be deemed admissible. Moving on to our second argument, we submit that the case against Mr. Gravis falls within the jurisdiction of the court pursuant to Article 19. And there are two counts of genocide, Your Honors, that will be addressed today. First, genocide by killing under Article 6A, which was perpetrated by the NDS and SPG. And second, genocide under Article 6C, which was perpetrated by the Federal Police Department. Turning to the first crime, there are two material elements that need to be met under Article 6A. First, that members of the protected ethnic group were killed, and second, that those killings were carried out with the requisite genocidal intent. As for the first element, we see that it is fulfilled because on the night of the 15th of July 2019, 200 Castilian men were shot dead. As for the second requirement, the one of genocidal intent, the Akayesu judgment and the Kayashem-Nuremberg one have provided us with 4 factors from which genocidal intent can be inferred. The first factor stems from the Akayesu judgment, and it is the deliberate and systematic targeting of victims pursuant to their membership of a particular group while excluding members of other groups. The second factor is again from the same case, and it is the targeting of children and pregnant women who would naturally not have been among the fighters. The third factor is from the Kayashem-Nuremberg case, and it is the use of derogatory language. And the fourth factor is again from the same case, and it is the cruelty with which the attacks were carried out. Your Honors, when we apply all of those factors in our case, they're clearly present because in case fact 13, we know that upon learning that Mr. X was of Han ethnicity, the NDS and SPG did not proceed with the commission of the crime, while at the same time, they executed 200 Castilian men, only 2 of which were CNF members. Furthermore, they were targeting pregnant women, which would naturally not have been among the CNF fighters. And while this was ongoing, the SPG officers were heard engaging in derogatory language, and they were chanting Castilians are cancer. And the cruelty of the attacks, Your Honors, can be witnessed from the facts surrounding the night of the 15th of July 2019, namely the context in which those killings occurred. We have SPG and NDS officers barging in the middle of the night into the homes of Castilian families, apprehending, arresting the men, and forcing them to admit that they were part of the CNF. And when those men resisted the arrest, they were shot on the spot. And while this was ongoing, their pregnant wives were begging for the lives of their husbands, and they were simultaneously getting kicked in the stomach by SPG officers. While all of this was happening, chants of Castilians are cancer were being heard. Your Honors, it is clear that the NDS and SPG possessed the requisite genocidal intent. Moving on to the second count of genocide. Under Article 6C, there are once again 2 material elements that need to be met. First is the infliction of certain conditions of life calculated to bring about the group's physical destruction. And the second element is that this infliction was carried out with the requisite genocidal intent. As for the first element, it was clearly fulfilled because we know from the elements of crimes that the term certain conditions of life encompasses deliberate deprivation of resources indispensable for survival, namely food or medical services. And from case fact 15, it was the police's actions, namely the deliberate deprivation of resources indispensable for survival, such as food, that resulted in the famine. Therefore, the first specific element under Article 6C was fulfilled. As for the second element, namely the genocidal intent, we would like to point the court towards the Kayashem-Nuremberg case, in which we have a very similar situation that occurred. And in that case, the chamber found that genocidal intent was inferred from the words and deeds of the perpetrators, and it was further demonstrated by a pattern of purposeful action. And this action included the gathering of Tutsi refugees in places where they would not be allowed to leave, and those places were surrounded by Hutu assailants. And furthermore, the Tutsis inside were denied food, medicine, and sanitary facilities. Furthermore, the use of roadblocks was present in the Kayashem-Nuremberg case, where those identified as Tutsis at those roadblocks were either arrested or killed on the spot. And some of the Tutsis that were arrested were later on taken to places where they would be subsequently either injured, mutilated, and some of the women would be raped. Your Honors, the ICTR recognized that the erection of roadblocks was a natural phenomenon during times of war. However, those roadblocks in Rwanda were unrelated to military operations, and they were used to identify the Tutsi victims of genocide. When we apply those facts to our case, we have an almost identical situation, Your Honors. We have the entire province of Kastyria being closed off and people of Kastyria being stuck inside. The entry and exit from and to Kastyria were completely shut down from the July 2019, possibly all the way up until now. And not only that, but the people inside of Kastyria were starving because not only was the blockade blocking everything to and from Kastyria, but the federal police department also forced the local businesses to close down. And from case fact 4, we know that those businesses were largely agricultural. Therefore, by forcing them to close down, they removed the possibility of Kastyrians to utilize their natural resources and to sustain themselves from it. Therefore, the blockade, in combination with the closure of businesses, led to the starvation of the Kastyrian people due to the restriction of food sources both from the inside and the outside. Furthermore, the use of roadblocks was also present in our case. And at those roadblocks, Kastyrians were either killed on the spot or they were arrested. And some of the girls that were arrested, some as young as age 13, were later on sent to places where they will be subsequently raped. Your Honor, this particularly destructive manner of extermination even captured the attention of the jury.
I'm sorry to interrupt you. My colleague would like to have a question.
Thank you, Presiding Judge. Would you agree there might be a difference in law between discriminatory intent and genocidal intent? And if you agree with that, what factors in this case do you think shows an intention to destroy the group, as opposed to merely discriminate against those who are perceived to be of Kastyrian ethnicity?
Well, Your Honor, there is a difference indeed between genocidal and discriminatory intent. And we claim that in this case, there was the presence of genocidal intent because the manner in which those attacks were carried out, specifically for the second count of genocide, this blockade, this closure of local agricultural businesses, it was which led the entire province of Kastyria to starve. And furthermore, the use of the roadblocks, which was completely unrelated to military operations or security threats, which were sending off girls to be raped subsequently to other places. This is clear that it was genocidal intent, Your Honor.
But so just to be clear, your argument is based on inference just from the conduct. There is no other evidence in your view that would support specifically genocidal intent?
Yes, Mr. President. However, direct evidence for genocidal intent is not required, and this was confirmed in the Akayeshu case. It can be drawn from inference of the words or the deeds of the perpetrator.
Thank you.
Your Honors?
May I briefly, sorry to interrupt, get back to the point you just mentioned. The genocidal intent which you just established, is that supposed to be the intent of the troops who actually organized the roadblocks and the specific acts you refer to, or whom do you actually attribute this intent to? Which are the perpetrators who have to have the intent you are talking about?
The perpetrators of the first count of genocide, namely genocide by killing under Article 6A, or the one surrounding the events of the night of the 15th of July 2019, the perpetrator in that case were the NDS and SPG, and they're the ones with the genocidal intent. As for the second count of genocide, the blockade, the starvation, the perpetrators were the federal police department, and they were the ones that were carrying the requisite genocidal intent.
Thank you. Please go ahead.
Therefore, Your Honors, it is clear that given the killings and the arrests of the Kastyrians at the roadblocks, the context within those arrests and killings took place, namely the starvation of the entire province, it is clear that the federal police department possessed the intent to destroy the Kastyrian ethnic group. And finally, both counts of genocide took place within a context of a manifest pattern of similar conduct directed against the Castilian ethnic group. And this pattern began with the violent suspension of Castilian parliamentary activity and the halting of federal payments, which then led to the introduction of a counterterrorism campaign. And then this campaign escalated into the various violent acts of the security divisions directed against Castilians, such as, for example, case fact 12, the killing of Castilian men, case fact 13, the violence against pregnant women, the case fact 14, the forced labor and the sexual exploitation of young girls, and in case fact 15, the starvation of the entire region. This concludes my submissions, and I will now yield the floor to my co-counsel. Unless there are any further questions, thank you for your attention.
Thank you. Please continue.
Morning, Mr. President, Your Honors, may it please the court. My name is Fikri Faruqi, and on behalf of the prosecution, I will demonstrate that Mr. Grafis was liable for command responsibility pursuant to Article 28A of the Rome Statute. To establish command responsibility, Your Honors, 4 requirements must be fulfilled. First, a person must have effectively acted as a military commander. Second, the person had effective authority and control over his forces. Third, the person should have known that their forces were committing a crime. And lastly, the person has failed to fulfill his duty to repress that crime. Turning to my first argument, Mr. Grafis was effectively acting as a military commander of the security apparatuses of Hanatun. Now, this court has defined the term a person effectively acting as a military commander in paragraph 409 of its Bemba confirmation of charges decision as any persons who has de facto control over regular governmental forces, such as the police. And we can see, Your Honors, that this is clearly the case, where in fact 11, Mr. Grafis has de facto control over the security apparatuses of Hanatun, including the NDS, SPG, and police. Thus, we submit that Mr. Grafis was effectively acting as a military commander of the security apparatuses of Hanatun. Now, moving on to my second argument, Your Honors, Mr. Grafis had effective authority and control over his forces. According to the paragraphs 416 of the Bemba confirmation of charges decision, a finding of effective control is more of a matter of evidence than that of substantive law. Factors indicating effective control we can find in the Bemba 2016 trial chamber judgment paragraph 188 includes, among others, first, the position and actual task of the commander. The second factor is his power to issue orders. And the third factor is his representation of the ideology in which his soldiers adhered to. Now, applying these factors, Your Honors, to the case, we can see for the first factor, again, this is clearly the case where in facts 1 and 7, Mr. Grafis was commander-in-chief of the security apparatuses of Hanatun. Some of the actual tasks that he carried out, we refer to facts 11, where he made policy objectives seen where he made the counter-terrorism campaign. For the second factor, this is also fulfilled where in facts 11 again, we can see this counter-terrorism campaign included orders. For the third factor, Mr. Grafis embodies anti-Castilian ideology, as we can see in facts 10. On national television, he called the Castilians cancer that must be eradicated off the map. This ideology can also be seen in his actions, such as reducing federal transfers to Castilla, as we refer to fact 6, and not giving any Castilians governmental positions, as seen in fact 7. Such ideology were adhered by soldiers, as we see in facts 13. While kicking pregnant Castilian women in the stomach, they were chanting out, "Castilians are cancer." Thus, with these factors in mind, Your Honors, there are reasonable grounds to believe that Mr. Grafis had effective authority and control over his forces. Turning to my third argument, Your Honors, Mr. Grafis should have known that both counts of genocide were being committed by his forces. Now, the should have no standard requires the commander to take an active duty to secure knowledge of the conduct of his forces, regardless of the availability of information, as this was held in the Bemba Confirmation of Charges decision, paragraph 432 to 434. Additionally, if we see the Von Leap case in page 603, this duty would be violated if the commander receives a report which on its face is inadequate, but does not obtain more reports. Applying these rules, Your Honors, to the current case, for the first count of genocide for the killing of 200 Castilian men, we can see in Facts 11E, Mr. Gravis required the heads of all three security divisions to report to him regularly and personally, but one has only done this, being Ms. Jolie, the head of the NDS. And there's a report we can see in Exhibit 1 is clearly on its face inadequate, as it only contains a few lines of information from Ms. Jolie and also a few reassurances from Ms. Jolie, and did not have any more information of the conduct of the NDS and SPG, only talking about the civilians. For the second count of genocide, Your Honors, namely the starvation of Castilla as a whole, there are no indications in the facts that Mr. Gravis even took an active duty to inquire about the police's conduct. Thus, with this, Mr. Gravis should have known that both counts of genocide were being committed by the security apparatuses. With this, the should have no standard being fulfilled, Your Honors, this triggers the duty to repress, as held in the Bemba Confirmation of Charges decision, paragraph 435. Which turns to my fourth and final argument. Mr. Gravis failed to take necessary and reasonable measures to fulfill his duty to repress. Now, the duty to repress, according to paragraph 439 of the Bemba Confirmation of Charges decision, encompasses two different obligations. The first obligation is to stop ongoing crimes, and the second obligation is to punish crimes committed by his forces which has already occurred. Some of the necessary and reasonable measures Mr. Gravis could have taken, some of the measures that he could have taken, Your Honors, is perhaps to order his troops to stop or order them to withdraw from the conflict. And this is consistent with the Bemba Confirmation of Charges decision, paragraph 500 and 501. Now, applying these rules, Your Honors, to the actual case at hand, we can see there are nowhere in the facts that indicates Mr. Gravis repressed the police of its ongoing crime of its blockade or punished the NDS and SPG from the killing of 200 Castilian men, where he had the ability to do so, having effective control over them ever since 2019. Thus, we submit that Mr. Gravis has failed to take necessary and reasonable measures to fulfill his duty to repress. Unless I can be further of assistance to you, Mr. President, Your Honors, this closes the submissions for the prosecution. Thank you for your attention. Yes, Your Honor?
Counsel, I see Judge O'Leary may have a question as well, in which case she can go first and then I'll follow.
Thank you, Judge Carter. I just have a question as far as the submissions being related to Article 28A, command responsibility and the Rome Statute. Is there any want of the prosecution for us as a panel to also look to Article 28B responsibility should we not find that his commander role is sufficiently found in the facts?
Your Honor, if we see the wording of Article 28B, this is a subsidiary means of liability to that of Article 28A. Thus, we can see that here in the case, Mr. Gravis, because he was effectively acting as a military commander, having effective control over these regular governmental forces, he would be encompassed in that of 28A, Madam President. Sorry, Your Honor. Unless I can be further of, yes, Mr. President?
Yes, just a brief question also regarding your submissions regarding the mens rea, the subjective elements of the responsibility under Article 28. Is my understanding correct that you that you only argue that that in this case there was no positive knowledge, only that Mr. Gravis only should have known about the deeds committed by his subordinates. Is this correct? This is my first question. And my second question is, you elaborated upon upon his failure to take necessary and reasonable measures to prevent such acts, but I'm not quite sure if you have referred to the point that these acts are actually a result of this failure to take effective measures. Is there anything which you might perhaps like to add in this regard? Thank you.
Yes, Mr. President. First, I will answer your first question. Now, we can see that in Article 28, it has its own mens rea requirement, being either the knowledge standard or the should have known standard. And here, the prosecution is bringing up that Mr. Gravis should have known that both counts of genocide were being committed by his forces. For the second question, Mr. President, we can see that the wordings of Article 28A as a result of, this is a causational element, and this only refers to the duty to prevent and not the duty to repress or refer to competent authorities. And this is consistent with the Bemba Confirmation of Charges decision, paragraph 424. Thus, because we're only bringing up the duty to repress as a separate criminal charge and does not need a causational element, we do not need to worry about this as a result of, Mr. President.
Counsel, if I can follow up from the presiding judge's question. Is the Bemba confirmation decision the only view that has been taken as to the nature of the causation requirement under Article 28? Or are there also other views that we might wish to take into consideration as a chamber?
Your Honor, we can see that for the causational element of the as a result of, currently the Bemba confirmation of charge decision and the Bemba 2016 trial chamber judgment has been the only court case for the ICC that talks about Article 28 for this. There has not been any other court cases among the for the ICC that talks about such such as a result of for Article 28. Seeing that my time has elapsed, Mr. President, Your Honors, this closes the submissions for the prosecution. Thank you for your attention.
Thank you very much. I would now like to go on and give the floor to the first defense counsel.
Your Honours, I make just two submissions today, both on jurisdiction ratione materia. I will show that the dolus specialis under Article 6 was lacking through both of these submissions. My first submission is that the Castilians were not targeted as an ethnic group, but rather as a political group. My second submission is that in any case, there was no intent to destroy a substantial part of Castilians. I turn then to the first of my submissions. Your Honours, the pre-trial chamber said in Bashir at 114 that a genocider has intent when he selects his victims for the national, ethnic, racial or religious characteristics. But we submit that the CNF was targeted for its political characteristics. The CNF does not have its own language, customs or traditional links to the land, factors which were considered in Bashir. Rather, the CNF is a legislatively created body which invites all national minorities to join, not just Castilians. The purpose of the CNF is not to foster its members' culture. Its purpose, rather, is to resist Mr. Gravis and fight for what it deems to be fundamental rights, as said at paragraph 7 of the facts. In addition, the ICTR said in Samanza at 317 that in determining the group that is the target of genocidal intent, we should consider the accused's subjective perceptions. Now, at paragraphs 8 to 11 of the facts, we can see that Mr. Gravis's hostility has always been directed to the CNF rather than Castilians ethnically. At paragraph 8, he calls the creation of the CNF an act of terrorism. At 10, he says that the military ambush was planned and executed by the CNF and their supporters. And he says that the deceased should be revenged. Now, we submit that on a natural reading, he's calling for revenge against the persons responsible for killing the deceased and not against all Casterians. Of course, we must address those perhaps controversial words, lying rats and Casterian cancer, paragraph 10. Now, this was corrected by the spokesperson to mean CNF terrorists, and we would submit that if Mr. Gravis was trying to go after Casterians ethnically, then he would be unlikely to make such a clarification. He would likely want to stoke anger, perhaps, towards all Casterians, like in Kayashima, for instance, with the infamous "get to work" remark, which encouraged listeners to take up axes and machetes against the victims. Now, corroborating all of this regarding Mr. Gravis's subjective perception is Exhibit 1, where Mr. Gravis thanks Ms. Jolie for releasing civilians who have been arrested by mistake. We submit that if Mr. Gravis had been selecting his victims based on ethnicity, then he would likely not have wanted Ms. Jolie to spare the Casterian civilians. Now, it is true, as the prosecution has submitted today, that the court may infer genocidal intent from the acts of the accused and others. And of course, to do this, the court would consider factors like scale, locality, and whether there is a systematic targeting on the basis of ethnicity. Here, however, the Casterians we submit were not systematically targeted. At paragraph 12 of the facts, it's clear that only the men who have resisted arrest were killed, and we submit that if the aim was to kill Casterians systematically, then likely the NDS would have gone after them all and perhaps killed them all, whether they resisted arrest or not. Now, the central piece of evidence, rather, to the prosecution's case is Mr. X, which we cannot but address, of course, at paragraph 13 of the facts. First of all, it is second-hand hearsay, anonymous, as he told it to the IHRD. And the Bagbo majority at 43, of course, said that no responsible adjudicator can base factual findings on evidence without good reasons to accept that the source of that information is sufficiently trustworthy. And of course, with anonymous hearsay, we cannot test the evidence. And as was said at Bember at 51, hearsay carries an inherently lower probative value. What's more, Your Honours, Mr. Gravis's regime has been toppled, and the new government is hostile to Mr. Gravis, having arrested him and transferred him to the ICC. Mr. X is also of Hanu ethnicity. So we say, why not rely on his evidence directly rather than second-hand anonymous hearsay? In the present context, there would likely be witnesses available to testify against Mr. Gravis. The prosecution is supposed to select its best evidence to present to the chamber today. Yet the fact that it has selected this evidence of all speaks, we submit, to the baselessness of the charges against my client. But let us for a moment accept Mr. X's evidence. Now, at paragraph 13 of the facts, it's true that the soldiers released him when they found out that he was Hanu. But the facts don't say that Mr. X was released because he was Hanu. They let him go once they found out he was Hanu, and there is coincidence there, but of course, correlation is not causation. We say that the CNF comprises mostly of Casterians and other national minorities, some other minorities, and the fact that Mr. X was Hanu, therefore, would have allowed the soldiers to make a strong logical inference that Mr. X was not a CNF member. According to Mr. X, also, the soldiers pressured him to say that he supported the CNF. But if the soldiers were trying to destroy Casterians ethnically, why would they need to do that? For they simply could have, with respect, just killed him. After all, a dead man cannot testify and does not need to be convinced that he was killed for his politics. All of this, Your Honours, we submit, suggests that the soldiers were genuinely trying to find out whether Mr. X was a CNF supporter, and that this was not simply some sort of ploy or mask. Accordingly, Your Honours, we submit that it was not the Castilians ethnically who were targeted as a group. Now,
Counsel, just before you move on, can I ask, in fact, two very small questions, and I'll be brief. The first question is on your last point about Mr. X's evidence, and you asserted that the prosecution has an obligation to bring its best evidence at this stage. Is that really true, bearing in mind that we are not yet even at the confirmation of charges hearing in this case, and that the prosecution is entitled to bring additional evidence at trial? So if you'd like to answer that question first, and then I'll ask my second.
The prosecution, of course, does not have to present all of its evidence at this stage, but its general practice, we submit that it would present its best at this point in order to maximise the probability of the chance, the trial proceeding. But moreover, we would say that the prosecution perhaps has, if not a legal duty, then perhaps a duty out of fairness to show evidence that the defence can perhaps evaluate at this point, rather than engaging in some sort of trial by ambush, as it were. So we would say that it doesn't have to present all of its evidence, but it should present its best.
Okay, thank you. And my second question, and you started off focusing very much on Mr. Gravis's intent. But of course, for these crimes, it's not Mr. Gravis's intent, which the prosecution says is where the genocidal intent lies. So in that case, how much weight do you really say we should give to Mr. Gravis's intent, when the reality is, the question for the court is whether or not his subordinates had the genocidal intent, even if they misunderstood what he was trying to tell them, that he was himself speaking against the political group. But nonetheless, that term Castilians are cancer, that seems to be the thing which is cut through to the physical perpetrators. And is that not the thing which should concern us about genocidal intent?
We'd say that Mr. Gravis's intent is relevant to the extent that it may allow for certain logical inferences as to the intent of the relevant persons. But of course, the main focus is those on the ground. But as I've just submitted earlier, we would say that even based on all of that, we could not possibly infer the requisite intent.
Thank you.
Your Honours, there is a brief point regarding the prosecution submission on the fact that only 2 CNF members were killed out of the 200 that were tragically shot dead. And we would say that the soldiers were perhaps unlikely to know at this time who was part of CNF and who wasn't, if it was a particularly fast-paced situation. And it may well be that the detainees were only identified after the fact. And of course, 12 of the facts say that they were targeted for their CNF affiliations. And additionally, as Your Honour Judge Cross suggested, we would say that factors such as cruelty and whatnot also that the prosecution referred to might go to, there is of course a difference between an intent to destroy and an intent to discriminate. And we would say that the cruelty would mainly go to the destruction element, but here we're particularly concerned with the notion of discrimination or how they are selected, on what basis. I'll briefly make submissions on substantiality as well. Of course, Kristich, Brijanen and ICJ genocide tell us that this substantiality requirement must be met, and we would submit that the numerical and functional approaches are most appropriate here. On the numerical approach, we submit that the targeted population was the militarized offshoot of the CNF, being the terrorists. And at 11 of the facts, Mr. Gravis in his order doesn't say the CNF generally. He narrows it down to one specific subset of that group. And of course, taking that together with the functional approach, we would say that the CNF isn't emblematic of Castilians as a whole, as was said in Ptolemy at 261. Unlike in, say, Ptolemy, the individuals killed did not constitute the core of the civilian and military leadership. And in that case, of course, one was a mayor, religious leader, and military commander all in one. And it's for those reasons today, Your Honours, that we submit that Mr. Graf has lacked the requisite intent. Those are my submissions.
Your Honours,
Thank you. Please go ahead.
I will be making our submissions in relation to Article 17 and Article 28A, that is in relation to the issues of admissibility and responsibility. Your Honours, even if this court is deemed to have jurisdiction over the matter, it still cannot hear the case against Mr. Gravis because to do so would be contrary to the principle of complementarity. There is, we submit, pursuant to Article 17(1)(a), an ongoing investigation in the Republic of Honiton, which renders the prosecution's case inadmissible. Now, we see at paragraph 18 of the facts that as of the 10th of December 2021, Honiton's military court has been investigating, among other things, crimes committed in the province of Castelia from the 3rd of November 2015 onwards. Your Honours, we recognise that for there to be a conflict between the exercise of jurisdiction in Honiton and in this court, they must relate to the same person and substantially the same amount of conduct. We find this in the pre-trial chamber's decision in Lubanga. And we would highlight that the broad scope of the Honiton investigation not only encompasses the conduct with which this court is concerned, but also the precision of its time frame indicates that it also concerns the same person, that is Mr. Gravis. We see at paragraph 6 of the facts that the 3rd of November 2015 is the day that Mr. Gravis came to power. Therefore, the scope of the investigation can be described as crimes committed in the conflict regions during the time that Mr. Gravis was in power. And therefore, we suggest it would be unreasonable to find that Mr. Gravis would not be subject to this investigation. And further, in relation to substantially the same conduct, Your Honours, we submit that Honiton's investigation does not need to cover exactly the same acts as the prosecution has relied upon in their case here. We find this at paragraph 83 of the Al-Gaddafi decision on admissibility. And further, not only are the precise acts not necessary, instead it's the underlying conduct that matters. But further, Your Honours, the case within Honiton does not need to have the same legal character as the crimes with which this court is concerned. Your Honours, turning now to a particular point from our learner friends from the Office of the Prosecutor, who made the submission that the investigation conducted by the military court is not sufficient because it's merely a preparedness to investigate rather than an adequate investigation in itself. And to substantiate this submission, Your Honours, reference was made to particular examples of investigative steps, such as interviewing witnesses or suspects, collecting documentary evidence, and such. It's our submission that on the facts of the present case, we're not privy to the details of the investigation, and therefore it's necessary to look to the facts of the cases where these principles were elucidated by this court in order to meaningfully deal with this element of Article 17. That is, Your Honours, looking at the facts in the situation in Kenya concerning the cases against Ruto and Sang as well as Kenyatta. In these cases, the purported national investigation into post-election violence in Kenya was primarily argued on the basis of general judicial reforms that were underway in the country, and further a fact-finding inquiry in relation to the post-election violence. In fact, one of the reforms involved removing the mechanism that would make it necessary to establish a special court for investigation and prosecution. Your Honours, in the present case, we find a stark contrast. In establishing a special tribunal in the form of the military court, Honiton does not rely on general future applications of judicial reforms, but has taken investigative steps that are specific to the case, the aim of which is not merely fact-finding. Your Honours, on this basis, we submit that there is an ongoing investigation in Honiton, and as a result, the case against Mr. Gravis is inadmissible. Your Honours, we also note, although not raised by the prosecution, that there may be questions relating to the willingness or ability of the military court to perform its role. And we submit that although the military court was formed after the initiation of proceedings against Mr. Gravis in this court, that it was not done so to shield him, but rather in response to external pressure. And further, the operation of this new judicial apparatus, and indeed the arrest of Mr. Gravis in the first instance, demonstrates an ability to obtain the accused and otherwise carry out proceedings, despite whatever impact the 2015 coup may have had on the judicial arm of government. Your Honours, we also submit that even if the court finds that there is no adequate investigation ongoing in Honiton, the case against Mr. Gravis is still inadmissible on the basis that it's not sufficiently grave. In the case of Akayesu, before the ICTY, genocide was declared to be the crime of all crimes. Even so, the statute of this court establishes an additional gravity threshold. When deciding the prosecution's Article 58 application in the situation in the Democratic Republic of Congo, the pretrial chamber held that it's the particular features, not the elements of an offence, which render it particularly grave. Therefore, an allegation of genocide cannot in itself demonstrate sufficient gravity. Instead, this must be evaluated from both a quantitative and a qualitative viewpoint. Your Honours, in relation to this submission, we could easily point to the number of victims of the acts within Casteria. However, we don't seek to diminish the tragedy that is the human loss of life. 286 deaths we do not submit is small or minimal. However, we submit that the particular features of the events in Casteria do not meet the required threshold for this matter to be admissible. And Your Honour, was there a question there?
Yes, thank you, Counsel. Are you going to address, on the point of gravity, comparisons with other cases which have been regarded as sufficiently grave at the ICC? Because on its face, 200 plus fatalities is pretty grave in terms of the numbers if you compare it to other ICC cases.
Your Honour, in relation to the gravity threshold and in relation to previous jurisprudence of this court, we would draw attention to the pretrial chamber decision relating to Article 17(1)(d), again in the situation in the DRC, which found that in addition to the scale and the systemic or otherwise nature of the offences, that this part of Article 17 is intended to ensure that the court initiates cases only against the most senior leaders suspected of being responsible. Therefore, Your Honours, even if, and indeed the court seems to find that the manner and number of deaths in this case is sufficiently grave, even then we submit that there is a further necessary consideration and that Mr. Gravis, though being a senior leader, is not one of the most responsible, particularly in comparison to the exercise of de facto authority by Mr. Bryan and Ms. Jolie. And on this basis, Your Honours, I'll move to our submissions on Article 28 and command responsibility. We submit that Mr. Gravis cannot be held personally and criminally liable for the alleged crimes of his subordinates because he had neither effective control nor the requisite mens rea. In the case of Bemba, the pretrial chamber affirmed that it's the failure to exercise the effective control in order to prevent and repress crimes, which gives rise to criminal responsibility under Article 28. And it's our submission that Mr. Gravis did not have such control over the subordinates in question, and therefore this duty to act did not arise. On the facts, Mr. Gravis has de jure authority as President and Commander-in-Chief. However, the existence of a superior subordinate relationship, that alone cannot be relied upon to demonstrate de facto control or effective control. The prosecution must demonstrate that at the time the crimes are alleged to have been committed, Mr. Gravis had the material ability to prevent and repress the crimes. The key aspect here, Your Honours, in relation to the submissions made by the prosecution is that the effective control of the superior must have existed at the time. There is a temporal nexus, Your Honours. And it's our submission that Mr. Gravis, regardless of what form of control he had over the security forces in the preceding years, or even at the time of the May 2019 declaration, we submit that by July, Mr. Gravis no longer had effective control over these forces because of the insubordination that we see on the facts. At paragraph 12, we see that only 2 of those killed were CNF members. And further, at paragraph 14 of the facts, we see the trafficking of young women and the killing of their male companions. Your Honours, even if Mr. Gravis is taken to have had effective control by issuing orders in May of 2019, these orders in relation to a specific national security threat are not being followed by the security apparatus when they are in hysteria. And we submit that this disrupts the effective control he would have had, and therefore his duty to act in relation to this does not arise. Your Honours, we further submit...
Sorry, may I interrupt with a question? Thank you, Counsel. When you're saying that the troops on the ground or the people who are actually committing the actions are not following the orders, was the order given by Mr. Gravis not broad in the context of this case, in that he said take any and all necessary measures? And particularly, I'm looking at para 11.3 in the file here, that they shall take any necessary measures they consider appropriate. Does he not bear responsibility then for deferring this judgment call to the people on the ground?
Your Honours, we would submit that, sorry, I note that my time has expired, so I'll answer this question briefly. Your Honours, we submit that the wording and the specificity of the May 2019 counterterrorism orders in terms of being broad is in fact another indication that Mr. Gravis lacked effective control, that it was then on a day-to-day basis the responsibility of other senior leaders, the heads of the security divisions, to determine the way in which these orders would be carried out. And we acknowledge, Your Honours, that there is not necessarily one person who must bear all responsibility, and that in pointing towards other individuals, this does not necessarily preclude Mr. Gravis from bearing responsibility. However, in the present case, Mr. Gravis is the only one against whom proceedings have been initiated. And we would urge the court to consider with caution the impact of importing the consequences of others' actions to someone when the connection is too remote. If there are no further questions, Your Honours, that concludes our submissions.
Thank you very much. I would now like to again give the floor to the prosecution to deliver further arguments in the sense of rebuttals. Thank you.
Good afternoon once again, Mr. President. Good morning, Your Honors. I would like to first present you preliminary clarifications before I proceed with the 3 points of rebuttal that the prosecution will be making. As for the first preliminary clarification, we know that it is inappropriate to consider evidentiary matters at this stage because the weight and probative value of evidence can only be considered when we have all evidence at the end of trial, as held in the Mamburashimana case, paragraph 44. And notably, all of the defense's evidentiary arguments are based on trial decisions, for example, the 2019 Bagbu majority opinion. Therefore, the court should postpone evidentiary deliberations until further stages of proceedings. And furthermore, as the argument by the defense that the prosecution should bring its best evidence, we would like to remind the court that the Mamburashimana case, all the way up until the confirmation of charges, was based on a single NGO report. Secondly, on the point of admissibility, we know from the Comoro situation that gravity is not solely assessed on quantitative considerations, but also qualitative ones. And that the mere fact that the scale of the crime is not comparatively high does not mean that it is not necessarily grave, because the crimes may still be of a cruel manner, impact, or nature. Moving on to our point of rebuttal, the first one will address the claim by the defense made on material jurisdiction, namely that Custurians or the CNF were targeted as a political group and that there was no genocidal intent. However, Your Honors, this was not our argument. We claimed that the targeted group was not the CNF, but the Custurian ethnic group in whole as such. And the Custurians, therefore, were clearly an ethnic minority as stipulated in clarification 1. Furthermore, the perpetrators clearly targeted Custurians and not CNF members because they targeted pregnant women who would naturally not have been part of the CNF fighters, and they also executed 198 men who were not CNF members as well. And furthermore, the fact that they released Mr. X, and I quote, "They found out that he was of Hani ethnicity, they released him but warned him to keep his mouth shut," is evident that the victims were targeted pursuant to their membership of the Custurian ethnic group, while members of other ethnic groups, such as the Hani one, were released. And the scale of the attack, which the defense has addressed, is irrelevant for this case because the contextual element of the crime of genocide requires that there must have been concrete threat posed to the existence of the ethnic group. And according to the al-Bashir arrest warrant decision, genocidal intent could still be carried out even if an attack was carried out against one individual with this genocidal intent. Moving on to our second point of rebuttal on jurisdiction, the prosecution claimed that Mr. Gravas did not possess genocidal intent. However, we agree with defense that Mr. Gravas did not possess genocidal intent. This is not required to hold him liable under Article 28A, and because this Article 28A is an omission form of liability. And the basic principle in criminal law is that material conduct must be committed with intent, and we have proven that Mr. Gravas' subordinates were the one that perpetrated the killings and the blockade with genocidal intent. And for the purposes of establishing that these crimes occurred within the material jurisdiction of the court, it is therefore irrelevant whether Mr. Gravas possessed such genocidal intent. Moving on to our third point on admissibility, the defense has claimed that there is evidence proving national investigations. However, we would like to reiterate the fact, Your Honor, that it must be evidence of sufficient degree of specificity and probative value, and we do not have in our case. And finally, we would like to address the command responsibility argument made by the defense and the fact that Mr. Gravas apparently failed the should have known standards. Your Honors, it is clear that Mr. Gravas failed to fulfill his active duty to take necessary measures to acquire information about his subordinates' conduct. And as regards the NDS and SPG, Mr. Gravas merely obtained one manifestly inadequate report from Mrs. Jolie, and he did not inquire further after receiving such incomplete reports. Thus, he did not exercise due diligence in the fulfillment of his duties. Furthermore, Mr. Gravas never sought reports from the SPG. And finally, as regards the police, Mr. Gravas never obtained any reports from Mr. Bryce, and then unquestionably fulfills the should have known standard for the police's criminal conduct. This concludes the rebuttal of the prosecution. Thank you for your attention.
Thank you very much. I would now like to move on finally to ask the defense to deliver its rebuttals.
Your Honours, I'll address each of those points in chronological order, beginning with the two clarifications made by my learned friend, the first of which concerned the appropriateness of considering probative value at this stage of proceedings. Now, we submit that this court should consider today to be an exceptional situation because of the prejudice potential that perhaps admitting this evidence might cause to the defence, which the court can, of course, consider under, say, Article 69, paragraph 4 of the Rome Statute. This is one of the items of evidence, if not the key piece of evidence, upon which the prosecution's argument rests. And we would submit that the prejudicial value of that evidence compared to the little probative value for the reasons that we submitted earlier would warrant it being excluded even at this early stage of the proceedings. Now, in terms of the submission on the Arrow Shimana case by my learned friend, first of all, of course, previous decisions are not determinative in this court and should not be slavishly followed. We would say that here we have this situation of there being a regime change and therefore, as submitted, the likelihood of there being available witnesses who would not really need to be anonymised, let alone expressed through second-hand hearsay. Turning to the points of rebuttal, first of all, as to the pregnant women, we would say that that relies on Mr. X's evidence, which of course we have impeached thoroughly during our submissions. And in terms of the 198 men, we've addressed that in terms of saying that it would have been difficult to ascertain at the time who was CNF and who was not. And finally, we have also addressed Mr. X being released for being Hanu. Now, the tail end that perhaps we ought to conclude with here is the Article 6C allegation that we would say, again, can be dismissed for similar reasons to the ones that we've submitted, simply that the intent there was not genocidal. Now, the ICJ in genocide at 189 said that specific intent has to be distinguished from other motives that the perpetrator may have, and great care needs to be taken in finding a sufficiently clear manifestation of that intent. And we would say that the facts clearly suggest that that blockade was set up to prevent CNF attacks. And of course, Hanatun was not able to ameliorate what happened there because of the economic situation. And it's for all of these reasons today that we would submit that there is no jurisdiction today in this court. Those are my submissions.
Thank you very much. If my colleagues have no further questions, I think then the oral presentations can be concluded with this, and we will retreat to further discuss your arguments. Thank you. Okay, good afternoon or good morning again. I would now like to ask my two colleagues to present, to give you some brief feedback. And before doing so, I would like to say thank you to both teams, and I would like to congratulate both teams for their excellent performance. If the rules would have permitted us to give you a tie, I'm sure we would have done that, but unfortunately this is not possible. So I will announce the winning team as well as the best speakers at the end. And again, I think overall, at least for myself, enjoyed this hearing very much. I learned a lot, and I was very impressed by the way also how you very persuasively included relevant case law, the jurisprudence not only of the ICC but also of many other courts. And yes, it was really delightful to listen to your arguments. Thanks again. And now maybe, yes, maybe may I ask Judge O'Leary to give us her comments.
Certainly. Thank you for the floor. And thank you to all the teams for the hard work and preparation you did for today and in these past weeks and months with this case. It's clear you're becoming quite fluent in it and in the law of this area. And that showed today in your submissions and in your response and questions and the ability to react. We appreciated that. So thank you very much. If anything, going forward at this stage, it's the semifinals. Congratulations for being here. Going forward, not just in next round, but in life, in all of it, we all discussed this familiarity you have with the material, just having the conviction in it then, and believe yourself, believe what you're saying. Some of you'd see points of it coming through. Really embrace and harness that to the degree that you can, because it really has this compelling factor that goes a long way in that the substance is there, but it sells it too. And I think that, you're all doing a really good job of that, and it can just be tweaked a little bit more as you have probably with each round and each day in this. So just keep doing what you're doing, I guess, and just keep, slogging through it to the very, very end, which is tomorrow. So thank you very much from my side, and I'll just pass on then to Judge Cross.
Thank you, Judge O'Leary. And first of all, yes, I absolutely agree with all that's been said. We really enjoyed your submissions. As you may have gathered, we found it quite difficult to make the choices that we've made. But we thought overall the performance was very finely balanced, as you'd hope in a semi-final. So we think, this has been a great semi-final. I'm going to give two headline comments, which are kind of along similar lines to those of Judge O'Leary. Again, please take these headlines as being like small adjustments. Nobody needs to make any radical changes. Don't change your styles. You're all absolutely going down the right path. But here are a couple of small adjustments you might like to bear in mind. The first thing is, I think, by doing submissions online, you're actually doing a task which is far harder, in my view, than making submissions in person in court, because we've got that gap which the technology creates between where you are on your side of the screen and where we are on our side of the screen. And so for that reason, if you can just notch up just a little bit the energy that you bring to your submissions, that will help kind of bridge that gap. I stress again, small adjustments. I like counsel who are not over the top. So I'm not saying overstate your case. I'm not saying, either get in each other's faces or get in the judges' faces. It's good to be, on the whole, less is more. I think that's right. But it's more in the way you deliver and just the way you try and slightly reach out across the screen if you can, because that's going to help make that connection, which helps build the persuasiveness. My second headline, which is kind of related to that, is if you get questions from the judges, embrace the question. Questions, as I'm sure you know, are not a bad sign. questions are a sign that you've said something interesting and you actually have reached out and you have got our attention, and there is something that we, want to know. And sometimes questions are, gosh, council, do you really mean that? We're not so certain. But other times questions are, oh, I've never thought about that before. That's really interesting. And I need you to tell me a bit more because I don't quite know what to make of it. Also, sometimes questions are one part of the bench talking to another part of the bench, kind of saying, hey, look at this interesting thing this person has said. Let's focus on that. So if you get the question, you all did a great job of responding. But again, slightly, you can lean into it a little bit more and don't necessarily see it as, that's the sound of the ice breaking underneath you. It might not be. It might be that's an interesting point. Please develop it. The flip side of that, of course, is sometimes you get a question which is, oh, bench doesn't like this. And then if you do get that sense of, oh, okay, maybe this is not going where I want it to go, then my answer would be bail out as fast as you can, elegantly, and move on. Don't reinforce an argument which you might be completely persuaded by, and you might even be right. But if it's clear that the bench is like, no, we're not certain about this, if you can get away and pivot to a stronger point, then probably I would consider doing that. But overall, fantastic performances. I loved every minute of it. So thank you very much indeed.
Thank you very much, both of you, for your very clear and very helpful, I think, and constructive comments on the great performance delivered by both teams today. I fully agree with what my colleagues have said already, and I really enjoyed the session. I also enjoyed the rebuttals, the way you not only presented additional arguments, but how you targeted what the other side mentioned earlier. So this was a very good and flexible way of interaction. And overall, this was a really very impressive session in my mind. So again, as indicated earlier, it was very difficult for us to make a selection, but as that is our job, I will now move on to announce the winning team, which is, the winning team is N03, the prosecution. Congratulations. And I furthermore have the honor to announce the best speaker. The best speaker was P1, Ms. Fakirova. Congratulations. And the second best speaker was D1, Mr. Liu. Congratulations. Again, this was a very difficult job for us to make such a selection, and but I think both teams made, and all speakers made a very good job. And again, congratulations to both teams, and thanks again for participating, and also for all the efforts you have made to advance to the semifinals so far. I wish you good luck for the. I wish team number N3 good luck for the finals, and I think also that team N33 made an excellent job, and you should definitely again participate in similar moot courts. I think you will have a very good chance to move on to finals in the future. Thank you again, and if there are no further comments or questions from my colleagues, then I think, as we are slightly behind time already, I would like to close today's hearing. Thanks again, and goodbye.
Thank you so
The
much.
International Criminal Court is adjourned.
Thank you.